We are wishing him good health and Godspeed, Johnny, and look forward to a full and complete recovery, and so glad to have you here. I'm also pleased that Senator Coons is on the floor, because I think it would be fair to say that members on both sides of the aisle who have watched how Senator Coons has conducted himself throughout this extraordinarily contentious debate would say that Senator Coons makes all of us very, very proud. It's no secret that he has tried repeatedly to bring both sides together, and he and I have talked often about this. I think there are going to be opportunities for finding common ground on some important legislation, breaking out of this gridlock that we all understand is not what the Senate is all about, and towards more mainstream politics. And when we get there, to a great extent, it will be because of the thoughtful comments of my friend from Delaware, and I appreciate it. Mr. President, the Senate is soon going to act on one of its most sacred and important constitutional duties, the advice and consent on the nomination of the next Associate Justice of the Supreme Court. The long tails of these Supreme Court debates stretch through generations and shape our government deep into the future. The choice the Senate makes in this extraordinary debate will have a profound impact from the broadest governing statutes down to the most specific particulars of the law that affect our daily lives. There are several issues, Mr. President, particularly relevant to this nominee that have gotten short shrift. I'm talking about secret law, warrantless wiretapping, death with dignity, and I intend to discuss these issues shortly. I would like to begin, however, by stating that whether one supports or opposes Judge Gorsuch, our job would have been easier had the judge been more forthcoming in his testimony before the Judiciary Committee. He chose, however, not to do so. So what the Senate has to go by instead is the judge's lengthy record of adhering to a rigid and far-right philosophy that is packaged in the branding of so-called originalism. The originalist says that our rights as a people are contained within and linked to our founding documents. But that viewpoint is plainly incorrect. And in practice, this originalism becomes a cover for protecting the fortunate over the poor, corporations over individuals, and the powerful over virtually every other American. It is a political agenda that masquerades as philosophy, an agenda whose sole intent is reserving power for those in power and limiting the recognition of the rights reserved to the people. Far from endorsing such a creed, our Constitution is actually a document of constraints, constraints that bind the government, not the people. The full scope of our fundamental rights as a people, as Justice Harlan once wrote, and I quote, cannot be found in or limited by the precise terms of the specific guarantees elsewhere provided in the Constitution. The exact concept is written into the Bill of Rights. The 9th Amendment says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. James Madison, the founder, so significant that Americans are said to live in a Madisonian democracy, was outspoken about the dangers of future readers or interpreters thinking that the fundamental rights contemplated by the framers were limited to the Constitution or a Bill of Rights. So our founding document and its framers made clear that rights were not enumerated by the Constitution, they were retained by the people. Individual liberties, from personal privacy, a woman's right to vote, the choice of contraception and abortion, interracial marriage, same-sex marriage, equal protection of the law. These liberties, and let me emphasize, many, many, many more have always existed. In fact, the Constitution and the Bill of Rights were silent on much of what Americans consider fundamental to a free people. That silence left the door open for the courts as we shed the prejudices of a darker age to recognize the true meaning of the words, all men are created equal and inalienable rights. But the progress has been painfully slow. The Constitution, like any document composed by politicians, is fraught with original sin. For example, the Three-Fifths Compromise was a shameful device of political accommodation. And through long stretches of our history, political agendas have left many individual rights unrecognized or unprotected by the courts. They ruled in favor of the powerful and against the disadvantaged and the disenfranchised, often with the justification that their rulings adhered to the text of the Constitution. Nowhere did the Constitution expressly deny women the right to vote, but the Supreme Court ruled against Virginia Minor in 1875. The federal government was not expressly granted a right to intern residents of Japanese descent, but the Supreme Court allowed it in Korematsu. There was no constitutional basis on which to deny people of different ethnicities the right to marry. On those issues and more, our judges were wrong. Supreme Court justices were wrong. In the service of the economic, political, and religious powers that be, the court has defended slaveholders, denied the franchise, permitted racial, sexual, and other discrimination, and routinely, Mr. President, elevated the power of the state over individual liberties. And any defense of those rulings as adhering to the text of the Constitution is just plain wrong. Let's look more closely at women's voting rights. In Minor versus Happerstedt, the Supreme Court found that women did not have the right to vote because the right was not expressly stated anywhere in the Constitution. In a unanimous decision, the court took the absurd position that a document predicated on voting, organized by voting, and dependent on voting for any amendment still did not protect the right to vote for all citizens. Such is the intellectual bankruptcy of a long legal tradition sustained by its defense of the status quo. The 19th Amendment was a response to the abridgment of a fundamental right by political parties and their dependent courts, but it did not create a new right. It was a long overdue fix made necessary by an originalist court. If there is a national evolution that extends protections of rights and liberties to disenfranchised and oppressed people, it is because with time, our wonderful country tends to correct its wrongs. It did so with the Civil War and the amendments that followed. It did so with women's suffrage and the Brown decision, and it did so more recently with the Obergefell versus Hodges decision. Historically, our country has gradually recognized fundamental rights and liberties. Recognition. I use that word intentionally. It is recognition because there are no new rights per se. They are inalienable, and those rights are not limited to those spelled out in the Constitution. A jurist governed by that principle would respect individual rights. But that simply isn't the viewpoint taken by many so-called originalists on the far right today. Their right-wing originalism looks, in my view, a lot more like the judicial philosophy that trampled on the rights of Americans in days past. A philosophy that throughout our history has left many Americans marginalized, disenfranchised, and oppressed by the state. And unfortunately, after listening very carefully to Judge Gorsuch present his views, reviewing his writings, including some I'll mention that specifically talk about my home state, I have no faith that Judge Gorsuch would be any different from this philosophy that I mentioned that has left so many Americans marginalized in our country. Judge Gorsuch not only has a long record of conservative activism in the courtroom, he has demonstrated an out-and-out hostility toward the right of individuals to make decisions about their own lives and their own families without interference from the state. In one troubling instance, he went so far as to author a book attacking death with dignity. This, of course, has been a matter that's historically been left to the states, and the people of my state twice approved death with dignity ballot measures, and our death with dignity law has been in place for nearly 20 years. The Supreme Court upheld it more than a decade ago in a case known as Gonzalez versus Oregon. But Judge Gorsuch's record and his own words puts the will of millions of Oregonians in question. Nothing in the Constitution gives the federal government the power to deny suffering Oregonians the right to make basic choices about the end of their lives. There is nothing in the Constitution that gives the federal government the power to deny people in my state the right to make those emotional, difficult, wrenching decisions about end of life. It is a private matter between individuals and doctors. And when politicians attempt to force regulations through the back door by going after doctors and their ability to prescribe, in my view, that is an obvious, over-the-line federal infringement. But my guess is there are probably going to be some folks on the far right that are going to try that route again. Nothing Judge Gorsuch said in his confirmation hearing gave me any indication he respects the death with dignity issue as settled law, or that he would rule against federal abuse of power to intrude on a private choice. The bottom line is that Judge Gorsuch is locked into an extreme right-wing viewpoint on this issue, and there is more. And part of this, Mr. President, is as I've listened to this debate, and particularly the number of comments that some of those who have espoused the views that concern me so much come back to, is they're always talking about states' rights. States' rights. That will be the altar that we really build our views and philosophies around. Well, I'll tell you, when you listen to some of what they're having to say about states' rights, what they're really saying is they're for the state if they think the state is right. And that is not, in my view, what fundamental rights, particularly ones that have been afforded the states, ought to be all about. So as I indicated, I think his views with respect to death with dignity really do involve federal abuse of power intruding on private choices, but there are other issues that concern me as well. He has made it clear in many instances he favors corporations at the expense of working people. He sided with insurance companies to deny disability benefits to people with disabilities, large companies to deny employees basic job protections. And he's even written that class action lawsuits are just tools for plaintiffs to get free rides to fast riches. No example better illustrates the tendency, my colleagues have talked about it, than the case of the truck driver in Trans Am Trucking versus Department of Labor. And in a case that just leaves you practically speechless, Judge Gorsuch sided against a truck driver who was fired for leaving his freezing cold truck when his life was in danger. I had another significant concern about Judge Gorsuch that came up in the context of his confirmation hearings, and this is something that I think a lot of Americans and even those in government are, I think, trying to get their arms around. I've been on the Intelligence Committee since the days before 9/11, and one of the things that we've come to feel strongly about is the danger of what I call secret law. And I want to make sure people know exactly what I'm talking about when I describe secret law. In the intelligence world and in the national security sphere, operations and methods, the tactics used by our courageous men and women who are protecting us, who go in harm's way to protect our people, those sources and methods have always got to be secret. They're classified, and they have to be, because if they got out, we could have Americans die. The people who do all that wonderful work, and possibly millions more. So sources and methods have got to be secret. But the law and our public policies always ought to be transparent. The American people need to know about them, because that is how we make informed decisions in our wonderful system of government. Voters are given enough information to make the choices. And so, sources and methods, operations, secret, but the law and political philosophies has got to be public. And Judge Gorsuch, as a senior attorney in the Department of Justice, was a practitioner of secret law. And as I indicated, the public isn't going to know about secret operations. We protect it, but trust in government and in our legal system can't survive when Americans understand a law says one thing and then the government or a secret court says it means another. Secret law prevents the public from knowing whether their fundamental rights are being infringed by an unaccountable, unconstrained government aided by compliant courts. And secret law also keeps the Congress in the dark. Congress, whose job it is to represent people and oversee the government. Congress, who, barring rebellion, is the only recourse of a free people against an executive judicial alliance of secrecy that infringes their liberties. And it's my view that secret law makes a mockery of the oath that members of Congress, justices, and each senator here have taken to preserve, protect, and defend our Constitution. Secret law is fundamentally corrosive to the rule of law in America. And as we learned during his confirmation hearings, Judge Gorsuch was a supporter of secret law. In 2005, the CIA was conducting a secret torture program. In May of that year, the Department of Justice's Office of Legal Counsel determined secretly that torture techniques such as waterboarding were legal. Somehow it deemed them consistent with statutory prohibitions on torture in the Constitution. This was extraordinary, willful, faulty legal analysis. It was entirely inconsistent with how the Congress and the public would read the law or the Constitution. So then, our distinguished colleague from Arizona, Senator McCain, who knows a little bit about these issues, having been subjected to them in the defense of our country, Senator McCain got passed the Detainee Treatment Act. And Senator McCain understood, having fought for our country, given fully of himself, that our government had to find a way out of this problem. And the McCain law prohibits the cruel and inhuman or degrading treatment that has been at issue here. By any measure, both the law, the language of the law, the clear intent of the Congress, and the context in which it was passed would leave every American to understand that a decision had been made by their elected officials to limit the power of government. But Judge Gorsuch, then an employee of the Bush administration, had a solution. In December of 2005, he wrote to the author of the Justice Department opinion, Mr. Bradbury, about a presidential signing statement that would magically transform the McCain law into an endorsement of torture. What Judge Gorsuch wrote was that the McCain amendment that prohibited cruel, inhuman, and degrading treatment was best read as essentially codifying existing interrogations policies. In other words, according to Judge Gorsuch, John McCain's law, the one that passed 90-9 in the United States Senate, that somehow John McCain's law endorsed torture when it did just the opposite. The issue came up in his nomination hearing. Judge Gorsuch's explanation was he was making the recommendation as a lawyer helping his client, which was the administration. I got to say, Mr. President, there's one thing we've learned. This just following orders defense has gone on for far too long in this city. It is a small and feeble excuse, unbecoming of a judge nominated to the highest court in the land. A judge justifying government violations in the law and the Constitution just so his boss can say, I was following the advice of counsel. That is making a choice to do wrong. The McCain Amendment, what we passed here in the Congress, did not green light torture. It did not codify torture, period. And anybody who's ever heard John McCain talk about this issue, describe his personal horrifying experiences with torture, knows that it certainly could not have been his intent in writing the bill. And any lawyer, especially one secretly advising the government, first has an obligation to the law and the Constitution. Judge Gorsuch's failure to recognize that principle and his choice to do wrong, in my view, disqualifies him from a seat on the United States Supreme Court. Torture is not the only illegal program on which Judge Gorsuch left his fingerprints. After news broke of the illegal warrantless wiretapping program, Judge Gorsuch helped prepare testimony for the Attorney General, which asserted that these authorities are vested in the President and they're inherent in the office. It added, and I quote, "They cannot be diminished or legislated away by other co-equal branches of the government." If that were the case, then no action taken in this area by the elected representatives of the people has any weight. The Foreign Intelligence Surveillance Act that existed since the 1970s would be just some kind of advisory statement. Section 702 of the Foreign Intelligence Surveillance Act, which we're going to debate this year, be little more than wasted paper. And the USA Freedom Act, which ended the bulk collection of law-abiding Americans' phone records, might as well never have been signed into law. Voting for those bills, voting to confirm Judge Gorsuch, call into question any member's commitment to those laws that we passed. In response to a question during his nomination hearing, Judge Gorsuch said that he didn't believe the Attorney General's testimony, and that, again, he was only acting as a scribe, as a speechwriter, and as such, he absolved himself of responsibilities for his actions. Again, I think that it's just wrong to use this as an excuse. Like the endorsement of torture, assertions of presidential authority to override congressional limits on warrantless surveillance rip at the fabric of the rule of law. Judge Gorsuch, a man who chose to get up and go to work every day for individuals who are violating the law, Judge Gorsuch had the power to say no, and he would not make that choice. Colleagues, the Senate is voting to confirm an individual to a lifetime position on the Supreme Court. What Judge Gorsuch has stood for and against over the course of his legal career, as we all go into this debate, we'll have to reflect on. A history of support, in my view, for secret, illegal, and unconstitutional programs is an unacceptable record for someone seeking a place on the Supreme Court. I'm reminded the Senate again and again in this talk how the Supreme Court has rubber-stamped the executives of has rubber-stamped the excesses of our executive and legislature over the years rather than to defend individual our liberty. That's the record. The Supreme Court rubber-stamping the excesses of the executive and legislature rather than protecting the individual liberties of the American people. My view is it's our job as senators to ensure that the Supreme Court does not repeat the errors of yesterday, enshrining disenfranchisement and discrimination and denying equal protection of the law based on prejudice and political agendas. And I believe the only way to prevent this abuse is to appoint judges who recognize that the judiciary is a bulwark against any attempt to infringe on our inalienable rights. So the bottom line for me, colleagues, is whether Judge Gorsuch recognizes that rights are reserved to the people. There is no respect for individual rights and liberty to be found in a viewpoint that allows for secret law to justify torture, that favors the powerful over the powerless, or that tramples on the rights of Americans to determine the courses of their own lives. Unfortunately, we have learned over the last few weeks, this is Judge Gorsuch's record. I oppose his nomination. I urge my colleagues to do the same, and I yield the floor.